We'll next hear the matter of Sherlock versus Austin. You may proceed, state your appearance, and let us know if you wish to reserve time to respond.
Yes, Your Honors, I wish to reserve 5 minutes for
All right.
Andrew Flores on behalf of Mr. Sherlock, who is present.
Okay.
Your Honors, we're here before this court on a basic fundamental question. Can individuals who have been previously sanctioned for owning marijuana dispensaries without a permit?
Could you speak up a little bit, please?
My apologies.
Yes, we need you to speak into the microphone as loudly as possible, please. You have a sort of soft voice.
I'll try to enunciate.
All right, thank you.
The question is, can these individuals who've been previously sanctioned for marijuana dispensaries, illegally operating these dispensaries, apply for a cannabis permit secretly with a straw man practice? That's in essence what the trial court has rubber stamped. They said that is petitioning activity and it is protected. Clearly, it is not. As has been discussed in our papers, the first prong is whether or not the activity being challenged is protected petitioning activity. That implies that there are some petitioning activities that are not protected. This is one of those. Clearly, the facts of this case are not in question. The facts are as follows.
So I'm just trying to grasp the argument that you're making. This is a SLAPP
That's
motion,
correct.
all right?
That's correct.
Okay, so you don't dispute that the activity that respondent undertook was petitioning activity?
I guess the issue is, Your Honor, that in essence, before you even get to that, you have to establish whether that petitioning activity is legal or not.
No, first you start by determining whether there was petitioning activity within the code, and then if the respondent admitted illegal conduct or it's indisputably illegal, then we can take a look at that.
Right. And I guess that's what I'm in essence trying to say, Your Honor. This is indisputably illegal.
That she never conceded any illegal conduct.
She conceded the facts that are illegal. Does that make sense? So in essence, the facts are as follows. She had a client who had been previously sanctioned for illegal cannabis activity. She was hired to represent this client. They then filed a petition under the straw man practice without disclosing that this individual, the person that was prohibited from owning this permit, was the true and fact owner. It's happened on 2 separate occasions. One was in the name of the principal secretary, and the other one was in the Rizuki Milan case, which the court may or may not be aware of, but in essence,
we're aware of it, yes.
Those individuals obviously had their own agreement to hide the true principal or controlling principal in this case. So they didn't disclose the agency, they didn't disclose the true owners, and they did this purposefully. And the reason was, again, the reason is because of the prior sanctions, which would have ultimately led them to having their petition denied. This is a clear violation of Penal Code 115. It's a false document liability. Not only did they not disclose the owner's interests, but they failed to disclose the relationship, as I just mentioned. This goes against the spirit of the law with respect to marijuana legalization. Transparency is key. The reason the preamble of these acts state that. They specifically state out that transparency is important to keep criminals from then legitimizing their criminal activity through this process, which is in essence what the defendants have done. Now, the one thing I want to point out, there's been some discussion, at least in the papers, about whether or not this application, whether it's mandatory or permissive. There's a recent case that just came out. It came out of the 4th District, Division 3, and it's called HNHPC Inc. versus the Department of Cannabis Control. Case number is G061298 came out in August, early August, August 3rd, I believe. In that case, the appellant sought to demand that the Department of Cannabis Control establish a database for irregularities in the movement of marijuana products.
Did you provide that citation to opposing counsel?
I have not, Your Honor.
Did you provide it to the court?
It just came out in August, Your Honor. I have not.
Well, this is September.
Fair enough, Your Honor. I have not provided it, no.
All right, can you address something else?
Sure. It's important to note that the interpretation of the respondents of the BNP, the Business Professions Code section that applies in this case, they're conflating two issues. There's section A that talks about the applicants, okay? And section B, the application. Section A is about the application, section B is about the applicants. So, in essence, what the legislature has anticipated is a situation where you may have multiple people applying for one permit and one person who may not qualify. In that case, it's permissive. The department can decide whether this person's minor ownership or what have you would bar them from having the application granted. However, section B is specifically to applicants, and it says they shall not be granted this CUP. So those individuals, had they been disclosed, would have been specifically denied this CUP. That's clear, and what they've done is conflated these two issues in order to make it seem as though they were all permissive, when in fact they're not. So the discussion of shall, I mean, we all know it's second day law school, shall means must for the most part. So in this case, that's exactly what it means. Now, it doesn't necessarily create a mandatory obligation on the Department of Cannabis Control. However, it does make it illegal. You cannot, it can't be given. Now, in summation, I think that...
Well, I thought the statute said that in subdivision B, that the existence of one of the listed conditions may support denial of an application.
Yeah, I must have gotten confused then, because the one that does say shall applies to specifically the applicants.
Well, actually, A says it mandates the denial of a license if one of the conditions set forth in B exists, but B says the existence of one of the listed conditions may support denial of an application.
And that's the key distinction there, Your Honor, at the end. The application, not the applicant. So one applies to the applicant, the other applies to the application. Like I mentioned, if you have multiple applicants on one application, then one of those incidents doesn't necessarily, it gives them discretion there. But if it's only one applicant, there's no discretion. It's shall.
Okay, so I'm trying to figure out why Austin's conduct in assisting somebody, somebody's application for a CUP was never granted. Why is that illegal as a matter of law? That's what you have to establish.
Your Honor, they have been granted. In this particular instance, the one. And then we have another dispensary on Federal Boulevard. That one was not granted, but it was given to another client of Ms. Austin's, which that's when we're talking about collusion and fraud and all those other things. But I've thought about this so many times about how to explain this to Your Honors, and I think the most analogous scenario that can illustrate this is if I have a client that comes to me, Your Honor, and says, Mr. Flores, I'd like to get a alcohol license, but I'm only 18 and I don't qualify because I'm not 21. And I say, okay, we'll figure that out. We submit an application. I'm an expert in this scenario. We submit an application using the straw man practice to get this license for this minor. How is that not engaging in illegal activity? I'm assisting my client in obtaining something that they should not have. I'm helping them commit a fraud, not only on the jurisdiction that's issuing these, but also on the court, because then I go into court and battle this out, right? So to me, the way I see it, they're engaging in the old, hey mister, can you buy me beer? That's in essence what this is. It's, hey mister, can you get me a cannabis dispensary, even though I shouldn't have one? And they have plotted and they have engaged in this activity purposely to do so. So obviously this runs much deeper and there are much more issues, but with respect to these alone, it can't be protected activity.
So you're relying on a statement that Austin made in some declaration in Razuki?
Well, that's part of it, Your Honor, yes. But again, they have not disputed those facts.
Or that evidence wasn't before the trial court in this case?
Well, again, I think that with the first prong, we're looking at what's pled, not what's proven. Before we have to prove those things, they have to establish that we haven't pled them appropriately. And I think in the pleadings, in the complaint, all this scenario is laid out clearly. Hours on. Thank you.
Good afternoon, Your Honors. May it please the Court, Andy Frazier on behalf of Gina Austin and Austin Law Group. Just like in his briefing, counsel relies on wild, unsubstantiated, conclusory allegations to support a conspiracy that doesn't exist. They don't contest that this is protected activity. What they argue is that the activity is illegal as a matter of law. But that narrow exception is very narrow, and it only comes into play for the purposes of the anti-SLAPP statute when there's uncontroverted and uncontested evidence that conclusively establishes the crime as a matter of law. There simply isn't such evidence here. The counsel relies in argument on Penal Code Section 115, which provides that every person who knowingly procures or offers any false or forged instrument to be filed, registered, or recorded in any public offices within this state, which instrument, if genuine, might be filed, registered, or recorded under any law of the state, is guilty of a felony. There's been no evidence that Gina Austin or Austin Law Group committed any elements of that offense. Again, there's allegations due strawman practices and the fact that, the underlying facts that, defining the issue as whether these other individuals who've previously been sanctioned can apply for the license, but that doesn't establish willful, knowing, and that it is a false or forged instrument. There just simply isn't any evidence, and there's nothing in counsel's papers or argument that established that there is any illegal activity that's been committed. The plaintiff relies in part, on a declaration that's submitted in a different case that was not before this court, and I filed a motion in opposition to their request for judicial notice, but I want to point out a couple of things along those lines. And I raised the simple and unremarkable proposition of appellate law that you can't consider documents that were not before the trial court. And the response in their reply brief responds to that simple appellate proposition by asking, what are the bounds of ALG's counsel legal representation? Does zealous advocacy allow ALG's counsel to dismiss the law and arguments in its client's own declaration? Is such not a misrepresentation to this court that makes ALG's counsel jointly liable with ALG as an after-the-fact accessory to ALG's criminal conspiracy? In other words, citing a proposition of appellate law, counsel then turns that into a after-the-fact conspiracy that I've engaged in by raising that issue. And they go even further. ALG, its clients and co-conspirators have until now been successful in having deceived over a dozen federal and state judges at the trial and appellate level into enforcing and or ratifying their criminal conduct. To appellant's knowledge, ALG and its co-conspirators have perpetrated the largest fraud upon the court in the history of the United States. Those are the outlandish statements made by counsel, which he makes clear includes this court as having been conceived as part of this grand conspiracy. On page 14 of the reply—
Ms. Frazier?
Yes.
Let me stop you there for a second. Putting aside the reference in the declaration that was not before the trial court, what is your understanding of why opposing counsel is raising this argument about the straw man? What is your understanding of that particular argument?
I believe, my understanding is that he alleges that this is a grand conspiracy. There were 19 people charged, and he alleges that they engaged in a conspiracy to have this practice to minimize or keep the number of marijuana applications in their own little group. But there's no evidence of that. There's no evidence that anything that the Austin Legal Group and Gina Austin represent certain parties, and there's no evidence that their mere representation was illegal. There are 4 conditional use permits that are in this grand conspiracy that's alleged. And Gina Austin, or Austin Legal Groups, she wasn't involved in 3 of the cups, and in one of them she represented someone for a short period of time, then withdrew it. So there was nothing even filed that could be in any way considered a forged document. So the answer to your question is that's the allegations, but there's no evidence that my clients engaged in any illegal conduct. Did that answer your question?
Yes, thank you.
Another thing I wanted to point out was that on page 14 of the reply brief, appellants cite an unpublished San Francisco Superior Court opinion that referred an attorney who filed false documents to the court to the district attorney's office in the state bar, and then uses that unpublished authority from a Superior Court case to...
Okay, we don't need to hear about that.
Okay, well, and I guess my point, Your Honor, is this case is full of allegations and requests to refer the defendants to the state bar, to the attorney general's office, to the, for criminal investigations based on outlandish allegations and conspiracies with no evidence whatsoever. And I didn't intend to argue that as only to show how outlandish these allegations are down below in the trial court and in this appellate court. There just simply isn't any evidence that supports their position that there was any illegal conduct by Austin Legal Group and Gina Austin. If the court has any questions, I'd be happy to otherwise answer them. Otherwise, I'll submit and ask the court to affirm the trial court's order.
Apparently, there are no further questions. Thank you.
Thank you, Honors.
We'll hear from appellant.
Just briefly, Your Honors. Now, this may be a problem of my own doing with respect to the facts and circumstances around this case, but the simple fact is that before this court, the only issue that I've brought up, that I've hung my hat on, is the strawman practice. Now, when opposing counsel gives their description of what they believe the strawman practice is, they go into this diatribe about a big conspiracy. That's not necessarily what needs to be addressed, because the strawman practice is simple. I have an individual who cannot own a CUP because of the prior sanctions. I then find someone or use their agent to file, apply for, get...
Mr. Flores, but the issue is that, at least as I understand, is that there's no evidence of those strawman practices. And so if you could address what you believe is the evidence that substantiates
the applications themselves.
Did you submit evidence in opposition? You argued the pleadings, but I'm trying to see if even the declaration wasn't before the trial court here.
Right, Your Honors. And again,
What was the evidence that you submitted?
Well, there was no evidence submitted, Your Honor.
Right, that's part of the problem, isn't it? Aren't you supposed to submit evidence on a SLAPP motion?
I understand, but that's only...
If I might interrupt, it seemed to me that we're here in the appellate court. You've got no record of any evidence to support this. There's claims of all sorts of misbehavior, not in the record, not supported by evidence. Whatever arm-waving value that presents, it does not help the courts of appeal trying to work through and reach a rational decision based upon the record. So if it's not in the record, for crying out loud, you shouldn't be arguing it, and you shouldn't be discussing it.
I understand the court's position, and it is...
It's not our position, it's the law. I mean, we can't consider things that aren't in the record before us.
I think the issue, Your Honors, is that the error in the trial court was exactly that. not looking at what has been pled as opposed to what's been proven.
No, it's not that. On a SLAPP motion, it's not just looking at the pleadings. The pleadings, you have to submit evidence to support your allegations, and you didn't do that here.
And I understand that, Your Honor. My argument is that we don't get to that position because everything else is uncontroverted.
That's not the impression I have. Austin didn't admit any illegality.
Well, Your Honor, because they're not saying that they didn't do the action, they're just saying the action is not illegal. I'm saying that they did the action and that the action is illegal, if that makes sense. We'll submit on that, Your Honor.
All right, thank you very much. Matter is submitted. We're in recess for another panel.